Namaskar, brothers and sisters, ladies and gentlemen, students and scholars, teachers and trainers, professors, professionals, officials, personal learners. I welcome all respected doctors and directors, honorable ministers and managers, honorable doctors, directors, advocates, advertisers, administrative advisors. I welcome the most honorable President Mr. Modi ji. Dr. Rakesh from USA, heartily cordially welcome. It is really nice time, nice place, nice action today that we are defining international law and human rights. New definition of international law. In ninth edition of Oppenheim's book, the editors of the ninth edition of Oppenheim's book, Sir Robert Jennings and Sir Arthur Watts, have revised Oppenheim's definition of international law. In their words, international law is the body of rules which are legally binding on states in their intercourse with each other. These rules are primarily those which govern the relation of organizations and to some extent also individuals may be subjects of rights conferred and duties imposed by international law. Further, states are the principal subjects of international law. States are primary but not exclusively the subjects of international law. To the extent that bodies other than states directly possess some rights, power and duties in international law, they can be regarded as subjects of international law possessing international personality. Moreover, only individuals but also certain territorial or political units other than states to a limited extent be directly the subject of rights and duties under international law. Thus, the above concept and definition of international law given in ninth edition of Oppenheim's International Law is nearly similar to that given by Stark and Fenwick. However, it is still deficient in one respect because it is still conspicuous for the silence regarding general principles of law recognized by civilized nations. In view of the foregoing discussion and taking into consideration the present state of international law may be defined as the body of general principles and specific rules which are binding upon the members of international community in their mutual relations. The term international community is very appropriate, for it includes states, international institutions, individuals, and other non state entities. Some other definitions, J.L. Briley. In the words of Briley, the law of nations or international law may be defined as the body of rules and principles of action which are binding upon civilized states in their relations with one another. According to Torsten Jihi, Professor Torsten Jihi defines international law in these words: the term international law means the body of rules of law which apply within the international community or society of states. The definition presupposes that states constitute a society and that this society has a legal system, international law or the law of nations. This is another way of saying that international law exists, that there is a body of rules having the character of rules of law which regulate the relations of states enter se. According to Hackworth, in the words of Hackworth, international law consists of a body of rules governing the relations between states. It is a system of jurisprudence which, for the most part, has evolved out of the experiences and the necessities of situations that have arisen from time to time. Queen Vicayan in the Queen Vicayan Lord Coleridge, CJ, defined international law in these words: the law of nations is that collection of usages which civilized states have agreed to observe in their dealings with one another. West Central Gold Mining Limited Company versus King. In this case, the court observed international law may be defined as the form of the rules accepted by civilized states as determining their conduct towards each other and towards each other's subjects. SS Lotus case says in SS Lotus case, international law was defined. International law governs relations between independent states. The rules of law binding upon states therefore emanate from their own free will as expressed in conventions or by usage generally accepted as expressing principles of law and established in order to regulate the relations between these coexisting independent communities or with a view to the achievement of common aims. Restriction upon the independence of states cannot therefore be presumed. Philip C. Jessup. Jessup has defined international law. International law or the law of nations must be defined as law applicable to states in their mutual relations with states. Judge Jessup further adds, international law may also be applicable to certain interrelationships of individuals themselves, where such relationships involve matter of international concern. Gray says, according to Gray, international law or the law of nations is the name of the body of rules, which according to the usual definitions regulate the conduct of states in their intercourse with each other. Hall says in the words of Hall, international law consists of certain rules of conduct which modern civilized states regard as binding on them in their relations with one person to obey the laws of his country and which they also regard as being enforceable by appropriate means in the case of infringement. According to Kelsen, international law or the law of nations is the name of a body of rules, which according to the usual definition regulate the conduct of states in their intercourse with one another. In its criticism, we can say the above definitions can also be criticized in the same way as Oppenheim's definition has been criticized. These definitions are not appropriate and do not properly represent international law as it exists today. Soviet definition and approach to international law. According to the Soviet definition, international law is the total of the norms regulating relations between states in the process of their struggle and cooperation, expressing the will of the ruling classes of these states and secured by caution exercised by states individually and collectively. Another eminent Russian writer defined international law as the totality of norms, which were developed on the basis of agreements between the states which govern their relations in the process of struggle and cooperation between them, expressing the will of the ruling classes and are enforced in case of necessity by the pressure applied either collectively or by individual states. After the death of Stalin, the above definition was slightly modified by inclusion of a reference to peaceful coexistence. In recent years, Soviet writers have laid a great emphasis on peaceful coexistence in relation with the Swan states. According to the Soviet view, the principle of peaceful coexistence should be the basis of the whole structure of contemporary international law. Only it is based on the principle of coexistence can international law best promote the cause of peace and mutual understanding between states. According to another eminent Soviet writer, international law can be defined as the aggregate of rules governing relations between states in the process of their conflict and cooperation designed to safeguard their peaceful coexistence, expressing the will of the ruling classes of these states and defended in case of need by coercion applied by states individually or collectively. This definition notes the class, character, and significance of international legal relations. The definition notes the class, character, and significance of international legal relations, the nature of the relations between them, conflict and cooperation, and the method of safeguarding and implementing the rules of international law. For example, their defense individually or collectively by the states themselves. The purpose of present day international law is to regulate relations between states and this way strengthen world peace and security. Although international law, like any branch of law, has a class, character, and pertains to the superstructure, it cannot express the will of states in the form of an international agreement or custom which has grown up over a long period. The purpose of present day international law is to promote peaceful coexistence and cooperation between all states regardless of their social systems. In its criticism, we can say the Soviet definition emphasizes struggle and cooperation between states will of the ruling classes, etc. But as pointed out by George Ginsburg, indeed, whereas today the trend in most of the world moves more and more in the direction of a qualified recognition that international law no longer applies to states alone but encompasses a variety of international personalities other than states as well, including possibly individuals. The Soviet have today adamantly opposed most aspects of such expansion of international law. Their jurists, with rare exceptions, continue to cling to a very conservative conception of what constitutes a subject of international law. The Soviet definition is not adequate because it does not mention international organizations, individuals, and non state entities as subjects of international law. It does not also include the general principle of law recognized by civilized states. In view of the breaking up of the Soviet Union and end of communism, their Soviet definition and concept, the Soviet Union and end of communism there. Soviet definition and concept have also undergone significant change. Chinese definition and approach to international law, according to a Chinese writer, international law, like all other branches of law, is created in a definite stage of making mankind's social development. The origin of international law is directly related to the creation of the state. International law, like all other branches of law, is created in a definite stage of mankind's social development. The origin of international law is directly related to the creation of the state. International law is created as a political, economic, and the relations among states emerge. In his view, only the definition of international law given by Soviet scholars explains the question of the contents and substance of international law. The definition, that is of wishing Chai, is adaptable to the international law of various historical periods, including the modern one. He points out that international law possesses the following characteristics of law in general. One is it expresses the will of the ruling class. Two is it is the aggregate of norms adjusting definite social relation. And three, grant it is guaranteed by enforcement measures. In his view, therefore, international law is a kind of law possessing legal validity. It is not what are called self-executing norms of morality. As pointed out by Jerome Alan Cohen and Hamda Hugh by the time the above article appeared in late 1957, the Soviet definition of international law that recites had been supplemented by the insertion after the words struggle and cooperation of the phrase designed to safeguard their peaceful existence. This change followed the CPSU's promulgation in 1956 of a new policy that required scholars to recognize that the purpose of present day international law is to promote peaceful coexistence and cooperation between all states regardless of their social system. Although the PRC, for example, People's Republic of China, began to emphasize peaceful coexistence as early as 1954, and although Chinese writer appears to have accepted the post 1956 Soviet modification of the definition of international law to include reference to peaceful coexistence. By the 1960s, the Chinese and Soviets' view of this slogan and its legal implications differed substantially. For example, on October 8, 1964, Wu Taifang, then a vice president of the Supreme People's Court and president of the Chinese Political Science and Law Association, stated imperialism is the basic source of war. Imperialism is the basic source of war, and American imperialism, moreover, is the most ferocious and ambitious aggression ever to exist in the history of mankind, and it is the most flagrant violator of the principles of modern international law. Naturally, democratic legal workers in various countries should engage in the thorough exposure of and determined struggle against it. However, modern revisionists nevertheless make great efforts to propagandize the carrying out of peaceful coexistence with imperialism without being subject to any principle, disseminating the view that contemporary international law is the law of peaceful coexistence with American imperialism. The development was mainly due to the conflict between China and Soviet Union, and the latter was referred as modern revisionist. But in the 1970s, even the Chinese developed relations with America, Britain, and other so-called imperialist powers, and hence once again a shift has come in the attitude of Chinese scholars. The Chinese scholars criticize vehemently the definitions of international law given by Oppenheim and other Western writers. In the view of a Chinese writer, these definitions cause us first to realize that bourgeois international law is created for the so-called civilized states and does not possess the spirit of democratic legislation in the international big family. In the view of bourgeois writers, only Christian states are civilized states, while non-Christian states, mainly Oriental states, are uncivilized states. For instance, Oppenheim said that before the First World War, China, Persia, Burma, Abyssinia, and other Oriental states were still uncivilized states. The creation of the bourgeoisie for distinguishing so-called civilized and uncivilized states is neither long history nor cultural. Even though China has 5,000 years of excellent culture, she was not included in the group of civilized states. The exclusion of Oriental states is from the exclusive club of civilized states reflect exactly the needs of the aggressive interest of the imperialistic monopolistic bourgeoisie, he added. Although bourgeois international law may in certain periods and under certain conditions play a role of mutual restriction among civilized states, it is mainly a weapon used by civilized states to control and oppress what they consider to be uncivilized states. The uncivilized states are their praise. The Chinese people feel very deeply here. In the past, imperialism seized the right of consular jurisdiction in China on the pretext that China was backward in the rule of law and uncivilized. By establishing spheres of influence, advocating the open door and equal opportunity of all, and even trying to partition China, imperialism treated China as a backward and uncivilized state which could be oppressed. In China, international law is regarded as a legal instrument in the service of foreign policy. In the words of a Chinese author, international law, in addition to being a body of principles and norms which must be observed by every country, is also just as any law, a political instrument, whether a country is a socialist or capitalist. It will be a certain degree utilize international law in implementing its foreign policy. As regards the subjects of international law like Soviet Union, the Chinese also do not regard international organization and individuals as subjects. In their view, the bourgeois theory concerning the subject of law is inconsistent with the principles of modern international law, but this view cannot be accepted as pointed earlier. While criticizing Oppenheim's definition that individuals have now become subjects of international law and can now, although only in a few cases, claim rights directly under international law and did not always do so through the medium of state. Similarly, international organizations have also become subjects of international law. They can enter into treaties, agreement or treaties. Charles J. Fenwick says, in the words of Fenwick, international law may be defined in broad terms as the body of general principles and specific rules, which are binding upon the members of the international community in their mutual relations. Appraisal Fenwick's definition is better than all the above mentioned definitions because instead of the word states, he uses the words members of the international community, which include states, international institutions, individuals, and non state entities. He also uses the term general principles. The definition is His definition is very short but pregnant with meaning and takes into account the changes that have taken place after the Second World War. Indeed, it is an appropriate and correct definition of international law. Whiteman says Whitman defines international law. International law is a standard of conduct at a given time for states and other entities subject thereto. In its evaluation, we can say this is a very brief but adequate definition The words other entities subject thereto may include international organizations, individuals and non-state entities. The words used in the definition are apparently very simple, but they are pregnant with meaning and very vast in their scope. Moreover, Whitman has also emphasized the dynamic aspect of international law. He writes international law is more or less in a continual state of change and development in certain of its aspects. The evolution is gradual in others it is evolutive. J.G. Stark in these words says international law may be defined as that body of law which is composed for its greater part of the principles and rules of conduct which states feel themselves bound to observe and therefore do commonly observe in their relations with each other and which includes also the rules of law, the rules of law, the rules of law relating to the functioning of international institutions or organizations, their relations with each other, and their relations with states and individuals, and certain rules of law relating to individuals and non-states entities so far as the rights or duties of such individuals and non-state entities are the concern of the international community. The definition of Stark is appropriate because it takes into account the changing character of international law and truly reflects the present position of international law. In its conclusion, we can say on the basis of these definitions, we may conclude that international law is a body of rules and principles which regulate the conduct and relations of the members of international community. The contention that states alone are subjects of international law is not only consistent with the changing character of international law but has become completely obsolete and inadequate. Individualistic character of international law is being replaced by the law of social interdependence. In re piracy, jure gentium, Lord Chancellor Sankey aptly remarked that international law is a living and expanding chord. In view of the changing character and expanding scope of international law today, international institutions, some non-state entities and individuals have also become the legitimate subjects of international law. Nevertheless, it cannot be denied that even today, as pointed out by Starr, it is composed for its greater part of the principles and rules of conduct which states feel themselves bound to observe and therefore do commonly observe in their relations with each other. Thus, international law is constantly evolving body of norms that are commonly observed by the members of international community in their relation with one another. These norms confirm rights and impose obligations upon states and to a lesser extent upon international organizations and individuals. Moreover, international law has effects on and is affected by the international relations, political thought and communication, as well as by the awareness of women and men in every state that they are part of those addressed by the United Nations Charter as being we, the people of the United Nations. Nature and basis of international law. Before we take up different aspects of nature and basis of international law, it will be desirable to discuss in detail the question whether international law is true law or not. This is necessary because the nature of international law is not the same that of national law. A number of conceptions or every even conceptions as to who is subject to the rules of international law as to acceptance of international law, entailing rights and obligations and the enforcement of them. I thank all my brothers and sisters, ladies and gentlemen, students, scholars, teacher, trainers, professor, professionals, digital learners, officer, officials. I thank all of the doctors, directors. I thank all adorable ministerial managers. I thank all honorable advocates, representative administrative advisors. I thank the most honorable President Modi. Thank you very much. Have a nice day. Nice to see all of you. Thank you very much.